This conference will now be recorded.
All right, well, we'll wait a few minutes while people log in. I like the mustache, Bobby. That's a good look on you.
Thanks, Aaron. I just shaved yesterday at my wife's request. It was getting a little out of hand.
So as we're waiting for people, I will just share with the group so you understand my commitment to ACUS. My home does not have sufficient Wi-Fi for me to trust to do this, so I came into the office today. The air conditioning is turned off in the BYU Law School building today, so that is why I'm not wearing a jacket, because it is cooking in this room. So I should get hazard pay for this. You should double my salary, Matt.
Thank you for doing that, Aaron. Aaron, did you get my note? You got my note about the Senate Armed Services Committee report.
I did get that.
Yeah, it's a shocker. I had a conference with the National Bar Association on Saturday morning, and I was preparing for it and stumbled across that.
Hey, Mark, who are we waiting for that is not on? I don't see number of the professors.
It's you and your ilk. We're missing Kate Shaw, Eloise Pasikoff, and Joseph O'Connell. Nope, there's Eloise. Sorry, Eloise. Hi. Let's see. I don't see. Is Jen New on? Nope. Gillian Metzger might be joining us via webcam, or if not via phone. And then let's see. That's Tristan. Mohammed Mesbahi. Is Mohammed here? And then I see Robert. John Cooney. David Apple was a maybe. Is David here? No, but otherwise, that's the list.
Okay, well, what I think we'll do is we'll get started. Let's go around and first of all, let me give the speaking instructions. So the way this has worked, I don't think this was much of a problem with our meeting, but with some of the others, is that as we've used Zoom or the Zoom replicate, we have found that sometimes it's hard to keep track of everybody who is speaking. ACUS members have full speaking privileges and can unmute themselves. If you are not an ACUS member, though, you can't unmute yourself. So what you need to do if you're not an ACUS member and would like to speak, send me a message in the chat function, and I will be able to then call on people that way. If you are an ACUS member, you will already be able to speak. Though if you are an ACUS member and can unmute yourself, keep yourself muted most of the time to avoid the background noise. Only if you have something to say, then you unmute yourself. Likewise, I think last time I thought it worked pretty well. Even for ACUS members, if you have something to say, just to ping me. But recognize that if you're not an ACUS member and you're trying to just jump in, that's why you can't, because there's a mute function that you don't have the ability to undo, but we can undo it for you. So just send me a message in the chat function and we'll go from there. Likewise, real fast, you know what, while we're waiting, let's do a quick introductions. I don't know if we did that last time. We'll see how this goes.
Can I just start something quick? So I think the chat function is disabled. At least I'm using the desktop app and it is.
Okay. Is that true, Mark?
Is chat disabled by organizer?
Being allowed to chat with 3 of you. There's Jen.
Well, all right. Well, what we'll do is we'll do introductions, and while we're doing introductions, I'll let Mark see if he can figure that out. And if we can't do it that way, then you'll just have to speak up, and we'll go from there. So we'll start with introductions. I'll start with myself. I am Aaron Nielsen. I am an ACUS public member and chair of the committee. I live out in Utah. I teach at Brigham Young University, and we'll go from there. I don't know if everybody sees the screen the same way I see it. If they do, Todd would be next in line. Is that how you see it, Todd?
Yes, I think that it's random who's on the screen, so I think you may have to call on people, Aaron. But
Sure.
I'm Todd Phillips. I'm with ACUS, and I am the technology manager for this meeting. So I'll be the one muting and unmuting.
Great. Mark?
Deputy Research Director at ACUS. I will be the one who will be amending the draft recommendations today, or doing my best to help with that.
All right, great. Nathan? I see a Nathan Tomaso.
I am the program specialist here, and I'm just doing administrative support.
Perfect, thank you. I see a Terrence O'Connor. Terrence, can you hear me?
I think Terrence is maybe one of the public members who we have to unmute and video screen automatically, if I'm not mistaken. Aaron,
Let's practice while we can.
Thank you. Thank you. I'm a lawyer in private practice, and I read Chris's draft report and thought a lot of it and wanted to listen to the discussion. Thank you for letting me in.
Sure, thank you, Terrence. I see a Toby Dorsey. Is Toby in the same bucket? All right, here we go.
Hi, yeah, my name is Toby Dorsey, and I am an onboarding liaison member for the Executive Office of the President, Office of Administration. I'm a lawyer for the General Counsel's office there at the EOP.
Perfect. Thank you.
For full disclosure, I was at one time I was the liaison member of the United States Sentencing Commission when I was on staff there. So I have some prior experience with working with ACUS.
All right, thank you. Jim Tozy.
I'm Jim Chosey, a senior something, presently with the Center for Regulatory Effectiveness.
All right, thank you, Jim. Ben Smith.
Hi, I'm a recent graduate from the GW Law School, and I helped Professor Eukin's draft or do research on earlier versions of this report.
Thank you. Reeve and then Matt.
Yes, I'm Reeve Bull, the research director here at ACUS.
Hey, Reeve, just so you know, you're pretty quiet. So next time, if we can make it a little bit louder, that worked okay for this time. Matt?
Matt Wiener, Vice Chair of ACUS and Executive Director. And before I turn it back over to you, let me just ask Toby. Toby, you are now a duly appointed member of ACUS, a liaison representative. You're not an onboarding member. You are on board. Are you a Toby? Were you previously on this committee?
No, I was on a different committee before. I am really just showing up not as a member of this committee, but simply as a member of the public for today.
Okay.
My committee assignment has not been determined yet.
Well, we could determine it right now, but we won't put you on the spot. And Aaron, tell us if Aaron, if it really does get too hot in there and you're sort of losing your bearings and so forth, just let us know.
For those of you who joined late, the BYU Law Building's air conditioning is not working today, so I am cooking, but that's all right. Bobby, you're on mute.
takes a few steps when you're on the phone. But yeah, I'm Bobby Ochoa, another ACUS attorney advisor. I love this committee and all its members, and I'm learning more about bid protests. Thanks for having me.
All right, great. And then Chris. Chris is our consultant. I'll let him introduce himself, but you'll be hearing a lot from Chris today.
So I'm Chris Hukins. I'm a professor at George Washington University Law School. I teach public procurement law there. I also teach internationally. And I worked on a very similar effort. I was really struck last time, Aaron, how similar it was. Worked on a very similar effort when I spent about 10 years being the technical advisor to the U.S. delegation revising the United Nations model procurement law. So thank you.
Tristan Levitt.
Hi, I'm Tristan. I am the General Counsel of the Merit Systems Protection Board, and in the absence of any board members, I'm also serving as the acting head of agency.
Great, thank you. John?
John Cooney, I'm a regulatory litigator. When I was at Venable, I did editing for a lot of my government contracts people in bid protests. And when in doubt, I always channeled Nash and Sabinic.
All right, Sean McGibbon?
Hi, I'm Sean McGibbon. I'm the General Counsel here at ACUS. And FYI, Toby, during your prior service, when you were liaison with the U.S. Sentencing Commission, you were on the rulemaking committee. Just FYI.
All right, thank you. Justine?
Hi there. I'm an ACUS intern this summer, so I'm just here to observe.
Oh, great, thank you. Eloise?
Hi, I'm Eloise Pasikoff. I'm a professor and associate dean at Georgetown Law School, and I'm a public member, and I'm a proud and happy member of this committee.
Thank you. Jennifer? Are you gonna chime in? We want to hear if it works for you. Jennifer? No?
Yeah, for now, I'm at the University of Chicago Law School.
And a former chair of this committee. Anne?
I'm Ann Joseph O'Connell. I'm a professor at Stanford Law School, and I love this committee.
This is great. Robert's gonna dissent. We'll wait. Judge Braden?
Hello. I'm a retired judge at the Court of Federal Claims, retired chief, and I spent this morning with some ACUS interns, which was really fun. And I'm interested in seeing where your committee work is going. I have a lot of admiration for the professor that's putting together the project.
Thank you, Judge. And then Robert.
Hi, can you hear me okay?
We can hear you.
Great. This is Rob Girouard, government member from U.S. Office of Personnel Management.
All right, so I think that's everybody. Are there any folks on the phone, Mark, or is that just this program?
We may have some folks listening in. I can't see them. We're supposed to have a couple of folks joining us by phone. They won't be able to participate because of the way the platform is structured.
Okay. All right. Well, there we go. We're going to get started. Before we do, though, at the end of last meeting, we talked a little bit about Department of Defense, who has not, as of yet, chimed in on the recommendations. So I was hoping either Matt or Reeve can give us an update of where things stand on that.
Great. So let me, I can go first. First of all, can you hear me reasonably well? Does this help with the headphones?
Better.
Great, excellent. So let me just sort of briefly, I'll be very quick, just to describe the outreach that we've undertaken to DoD, and then I'll turn it over to Matt with a suggestion perhaps for procedure in light of what we've heard so far from DoD. So we have sent after last meeting, we reached out again to the public member of DoD, Paul Kofsky, who is the Deputy General Counsel over there. In addition, Mark and I spoke with Professor Hukins, and he provided a number of contacts, several of the Air Force, who I guess are very, very active in this space. And we reached out to several of those individuals who have also put us in touch with some people at the Army, as well as parent DoD. And Mark has been undertaking some outreach on that front We've not yet had a chance to speak specifically to the individual from the Army who I believe is chief of bid protest over there. I understand Mark has a call scheduled with him later this week. But basically, the outreach ongoing has borne fruit so far, and we'll have more in the next few days on that front. And let me turn it over to Matt with perhaps a possible suggestion on the procedural front of what we should do in light of that continued outreach or continued feedback that we're receiving.
Reeve, Mr. Kofsky is the ACUS member, correct, from the Department of Defense?
That's correct, yes.
All right. I wrote a letter to Mr. Kofsky after the last meeting inviting the DOD to make its views known to the extent it wishes to do so with respect to the draft recommendation. I have not yet heard it. I have not yet heard back from the Department of Defense. I realize obviously that Mr. Kofsky works in a busy office, the General Counsel's office. What I would propose, Aaron, on the assumption that you will probably bring everybody to consensus today at the second meeting rather than requiring or having a third meeting, what I would recommend is that that the committee postpone any final vote or official vote on the recommendation for, let's say, another week to see if the Department of Defense wishes to be heard on the recommendation. Does a week sound, to Aaron and Reeve, does a week sound like an appropriate amount of time?
It does to me. Would we vote via email? Would that be the thought?
We could do that depending on where you land at the end of the day today, yes.
Okay. That makes sense to me.
I just think as a matter of comedy, we should allow the DOD to a little bit additional time to weigh in here.
I'm okay with that. I think that makes a lot of sense. I would, subject to what they say. If it's a lot, then we'll call another meeting. If it's not a lot, then I'd like to do it via email rather than make everybody schedule another meeting. But we'll know better when we hear back from them. So hearing no objections, I think that makes a lot of sense. Did anybody disagree with that? Scanning the virtual room here. Nope, I think that makes a lot of sense. Thanks, Matt. Okay, all right. So this is, hopefully everybody has the revised draft of the recommendation. This is how I propose to do it. We went through almost all of the actual recommendations last time. We didn't do what is now, I believe, 8 through 11. Let me look at the numbers here. Yeah, 8 through 10. We didn't cover those. But you'll notice if you look at the draft that Mark sent around that we have some additional comment bubbles next to some that we've already gone through. So my proposal is let's just go down the line with the comment bubbles. So the ones we've already covered. Then we'll do 8 through 10. Then we'll go through all of them one more time to make sure we're okay with the actual recommendations. Then we'll end with the preamble to make sure the preamble matches what we've got. So we'll start with number 1. And number 1, this is, I'm going to ask you to explain, Chris. You recommended that we remove recommendation 1. Can you explain your thinking on that?
Sure. So recommendation 1 would create a presumption that everything that has to do with procurement, much like the Court of Federal Claims jurisdictional statute in 28 USC, anything that has to do with procurement would be subject presumptively to an agent's double bid protest. That might be controversial because there are some classes of protests that are, for instance, other transactions. There's a class of procurements called other transactions, which arguably may or may not be subject to bid protest. There's only been one decision in the COFC that I'm aware of. Judge Braden may be aware of another on other transactions, and GAO is still struggling with it. At the same time, and also just to bring the whole group up to speed, the exchange I had with Aaron before, I was preparing for a presentation with the National Bar Association on Saturday, and I went closely through the National Defense Authorization Act materials for that. The National Defense Authorization Act, Title 8 of that act, is every year it's been passed for over 50 years, but every year Title VIII of the National Defense Authorization Act is the vehicle for reform in my world, in the procurement world. And the House and Senate have both this last week passed their versions of the Defense Authorization Act. It's going to conference. Section 846 of the Senate version of the National Defense Authorization Act would reverse a pilot program regarding bid protests. It was a pilot to see whether or not it would be possible to shift costs to a losing major protester, and bid protesters would be a way to discourage protests by major protesters. Section 846 brings that pilot to an end, but also says that the Senate Armed Services Committee is concerned about making bid protests effective, and therefore the Senate Armed Services Committee is calling on the Defense Department to undertake a study of agency-level bid protests. I was completely stunned to see this. So the Senate Armed Services Committee has called for a study of agency-level bid protests, a report that would be issued by the Defense Department in early 2021. And again, it's tied to Section 846 of the Senate version. In the conference report, what tends to happen is in relatively non-controversial provisions like this, the conference report tends to absorb those because the staff people who are running Title VIII don't want to waste time on non-controversial provisions. So where there's a non-controversial provision like this, they're likely to take it into the final conference report. And I would be willing to bet money that they include this call for DoD report on agency level protests. I wanted to share that with the committee because it means that in essence the committee's recommendations will be part of the Defense Department study being done over the next year. Thank you.
So my reaction to this, and I'll let other members of the committee respond, is I don't feel strongly about the presumption. I don't know enough. I don't have enough knowledge to know whether there should be a presumption. I wondered about the middle sentence, though, about agencies should clearly identify which categories of procurement decisions I would change it, may be made subject to agency level protest. I don't. That's not a substantive point. That's just a transparency point that I think would be helpful for people to know. Do you have an objection to keeping that in, Chris, or is it just the presumption that is your concern?
No, I actually like the presumption personally, but I don't want these, because of where we are right now, Aaron, in terms of, among other things, writing on top of a DoD report. I don't want anything that's likely to make this report or make the ACUS recommendations look like they're controversial or outriders. Anything that's sort of jagged, my recommendation is pull it out, because this issue of jurisdiction is something that GAO and the Court of Federal Claims are going to resolve anyway. Regarding, for instance, other transactions, which are billions of dollars of transactions. I'd let the subject matter jurisdiction issue resolve itself and pull this jagged piece out so that the ACUS recommendations excite no controversy. Instead, they can be assimilated in the DoD report as non-controversial, as meritorious.
But is anything that I think that's a worthy goal. Is anything in that contrary to agencies should clearly identify which decisions may be subject? Again, I'm not putting a thumb one way or the other on that. They would just tell you what you can bid about, what you can protest and what you can't protest. Is that problematic?
Yeah, it would make more sense to make it a negative list. It should be which are not subject to an agency level bid protest. A negative list. If you wanted to keep this whole section in, it should be a negative list. Because doing it otherwise, unless you make it as open as 28 USC, I think it's whatever the Court of Federal Claims protest jurisdiction is. It's under that is an incredibly broad statement of jurisdiction. But again, this is a whole quagmire I would recommend that the committee stay out of.
Okay, so Mark, put a knot back in there, and I'm going to ask members of the committee if they have any opinions. For what it's worth, my opinion would be to keep in the middle sentence and get rid of the others. But you know, I'm curious what other people have to say. Eloise, you want to chime in?
Sure, just to agree with you that taking out the presumption doesn't mean we shouldn't be advocating for transparency about what the agencies have decided. And I think the transparency point is in keeping with other points that we make in the recommendations and indeed in the preamble, although we haven't gone there yet. But so I'm in favor of keeping that middle sentence just because it fits with the spirit of everything else we're doing in terms of transparency.
Anybody else? I see Jim has sent a chat to me. Jim, do you have thoughts for the whole group?
My concern on this is that, having spent 8 years in defense before I went over to OMB, that I think there may be some concern on the part of the department on this. And I'm not in a position to say what it would be, but I think that when we want to know DOD's position on this, and I would rather reserve final decision on this till you hear from DOD, because I think DOD is going to have a problem with the presumption that how big this umbrella is.
Okay, well, let's break this down. Does anybody want to defend the presumption? We can, for our conversation's sake, does anybody want to defend the presumption? If so, speak up now. Or at least send me a chat saying you want to speak up and I'll call on you. I think that we all agree that we don't need the presumption. So now the question is, if we get rid of the presumption, do we want to get rid of the, by the way, agencies should clearly identify which categories of decisions may not be subjects of agency level protests. I see Jennifer has a hand raised. Jennifer, no?
Yeah, so I just want to echo what you and Eloise are saying. And I just had a background question that might intersect with the preamble, because I don't know if the preamble discusses this, but I'd like to know how much of this jurisdictional question is statutory versus executive, because from how the report is written, it sounds like the agency's own jurisdiction, it used to be the executive order and seems to be now in FAR regulation. So it's completely at the, is it right? It's completely at the discretion of the executive branch to determine the jurisdiction of the agency. Is that right?
That's a question for Chris.
I just want to clarify that because.
Yeah.
Yes. Okay. So if it is, then I don't know. I mean, you've done so much research. It just strikes me that we could say something substantive about like when it generally makes sense to have the agency involved versus not. I mean, I get that. I get the politics and I get not wanting to do the presumption. At a minimum, I agree with everybody that they should be transparent, but couldn't we say something about, I just can't imagine a situation when the agency shouldn't be the first kind of port of call to adjudicate the issue.
No, I completely agree with you. Just and I'd be clear, as a professor, I absolutely think there should be a presumption. As a Washington lawyer, I know that if we have this at the beginning of the discussion and we have a negotiation among all the various stakeholders, we will be losing chits on this presumption. We will lose the argument and we will have lost those chits later on for procedural changes that really should be made and are much less controversial. That's my reason for recommending that we pull it. But from a professor standpoint, I think presumption is very important because there should be no dollar spent that is not subject to accountability. That's my very firm belief as a professor.
Well, this is I guess a prudential call for the committee. My philosophy on this is the whole point of ACUS is to try to get it right, and that we shouldn't pull our punches. We're not making anybody do anything. We're just giving good advice. So if that's your view, and DOD hasn't chimed in yet, my thought would be to stick by our guns and go with what we think is right. I wish I had a better sense of what I think is right here. I just don't know what we mean by this presumption, like what the carve-out list will be. Is it going to be, 55% of things should be covered and 45 will be outside, in which case the presumption is not really doing very much work? Or are we talking 90-10, in which case I think we should have the presumption? I just don't know. Empirically, I just don't know the answer to that. And I don't know if anybody other than Chris and maybe Judge Braden has that sort of in the weeds knowledge about how this works to decide whether as a committee we think a presumption makes sense. So I'll throw it out here. Here's a question I'll throw to the group. Is there anybody who has enough knowledge who could speak confidently about whether there should be a presumption?
Do you mean on the merits, Aaron?
On the merit.
Side.
Politics aside, we're leaving politics aside. I think that's a separate question. Let's just try now to get what the right answer is. I don't know the right answer. I heard from Chris, who thinks the right answer is a presumption. I hear that he thinks other people will say the right answer is not a presumption. I don't have the knowledge to say if Chris is right or these other people are right. I just don't know. So I'm calling on the wisdom of the group here. And it's possible nobody on the committee does, in which case my instinct then is not for politics reasons, just for lack of knowledge reasons, that we would go with the transparency but get rid of the presumption.
It's Judge Braden. It says agencies should operate under the presumption that in general, all types of procurement decisions that otherwise might be subject to protest might be subject to. It seems to me that what you're basically saying is that the statute tells you what is subject, the statutory authority for the GAO and the court. And I mean, what the agencies think or don't think is irrelevant. I mean, the statute says what the jurisdiction is. And then I think if you want to say, I think that's what you want to say, that you want to add into it, in addition to that, what you want is I think this is what the professor wants to do. You are suggesting best practices would be that the agencies have an internal, informal adjudication option available to complainants. It seems to me that the text is backwards.
So Chris, what is your response to that? I thought that there was discretion here. Is it?
No. You start with what the statute says. The statute says, what bid protest may be taken to the GAO and the Court of Claims. That's item 2. Item 1. Item 2 is that we recommend that it's best practices basically for the agency to have a internal, dispute mechanism. I think that's what you're trying to do with this, is it not?
Chris?
Yes, but the problem, the one practical problem with the way it's set up right now is that it's absorbing, or it's following the jurisdictional statutes of GAO and the Court of Federal Claims, and those remain. Those still present issues that haven't been fully resolved. For example, the Federal Circuit hasn't been presented with a case to decide whether or not the Court of Federal Claims can hear protests regarding other transactions, which are arguably outside the FAR. Other transactions are, and then therefore there will be people inside government, executive branch, that argue that those other transactions are not subject to an agency level bid protest either. That's the problem. It's still very much a mushy area, and mushy area.
What other transactions are you talking about?
The other transactions authority. So that's which is a distinct class of procurements, and therefore a distinct class of protests.
I think it's pretty clear that the statute basically provides the court's jurisdiction. Mm-hmm. If it's not in the statute, then it ain't there.
That was the issue that Judge Grigsby struggled with in the SpaceX case, and she said that she sent the matter to the district courts and the Senate. She said the Court of Federal Claims didn't have jurisdiction. So yeah. It's a tough area.
Well, but this is the predicate for your recommendation. What this is here, and I think you should start with the statute. The statute says, what's there, and what the purpose of this study is to, or this paper basically is to suggest an alternative dispute resolution option that's available to the someone who's not satisfied and doesn't want to spend the money to go to GAO or the Court of Claims. Isn't that right, or am I missing something?
I think that's fair, and in fact, the report went back to the statute, went back to the Court of Federal Claims jurisdiction section. I've got it here. It's 28 U.S.C. 1491B, which gives the court jurisdiction to hear any action involving a solicitation by a federal agency, or a proposed award, or the award of a contract, or any alleged violation of statute or regulation in connection with a procurement. So it's an incredibly broad statute. I think that's how the rule should be framed. But because this is such a political hot potato right now, and there's so many people invested in keeping the other transactions category exempt from any review, my fear is that those opponents of accountability, those opponents of protest, would destroy this entire initiative if we open up the subject matter can of worms.
Jennifer?
Sorry, I was trying to send a chat to the whole group, but I just had a question. So do any of these statutes preclude the agency from reconsidering its initial decision? Because if they don't preclude them, I don't understand either the politics or why we're talking about the statutes. As long as they don't preclude it, I don't see any reason why the agency can't, design, just as the recommendations are suggesting, this entire executive kind of alternative dispute resolution mechanism within the agency to reconsider its own decision.
That's correct. None of them do. I think the hardliners in the agencies would like to say that there's just no review at all of certain classes of procurement because they're outside the federal acquisition regulation. That's the argument they would like to make.
But the federal acquisition regulations are also internal. I mean, in other words, they could also be changed, right? So I still don't see any statutory barrier.
Yeah, no, there isn't any. And the way to deal with this would be to say, as we have here, is that if the agencies wanted to pull classes of transactions out of accountability, they could do that. They could just say, for instance, other transactions authority, which is what this class of procurement, this very politically dicey class of procurements, they could say other transactions are not covered by this agency level bid protest function. That would be perfectly plausible.
Right, but we as ACUS want to give best practices. And if we think that the agency is trying to duck accountability by pulling those classes out, we are recommending that they don't do that, right? Or we have something to say about that. And so I know this is just to clarify in my head, at least for the discussion, that these statutes, I think, aren't relevant. I mean, we are trying to, I think, make recommendations to design the entirely executive kind of internal dispute resolution, or this for reconsidering their protest decisions after the first adjudication.
It's completely the committee's decision. My job is to tell you what a possible way forward is, and also as a Washington lawyer to tell you where I'm scared. That's all.
Yeah, I guess I just don't see where the political fear comes from, because again, I mean, it's not about the statutory jurisdiction of either GAO, or otherwise. So anyway, this is just to say I at a minimum agree with the transparency, and I think that I agree with Aaron's initial instinct, which is to say, look, let's just recommend the best practices, and let the chips fall where they may. I don't really see the need for that type of fear in this situation.
Aaron, may I jump in here? I don't have a vote on the committee, and I don't have a suggestion on the merits. I would recommend that the committee just call this one on the merits, politics aside. This political issue has not come up before, and if we run into a problem down the road, the committee or the assembly can revisit the issue at that point. That's my sense of the matter.
That's my philosophy as well on these. Like I said, these are recommendations. We're trying to make the world as good as we can make it. And if folks don't want to do it, then that's fine. But that goes to the question, which is, I don't know on the merits whether I think a presumption makes sense or not. I just don't have the information. I do have a sense that the transparency, I don't know any reason why we wouldn't have the transparency. So because I lack that knowledge, my instinct is to go with what I know and not opine on what I don't know. And as I don't know if there's that much knowledge on this particular question in the committee, I think the more prudent course would be to keep the middle sentence and get rid of the first and third sentence. So keep transparency, not get into the issue of presumption, because we don't know enough to know if a presumption makes sense or not. But I'm happy for people to push back on that. That just makes the most sense to me. So let's let that proposal right now. Does anybody want to be heard on that proposal of delete sentences 1 and 3, keep sentence 2?
I just want to add a quick thing that if we do that, I think the sentence should read may or may not be made the subjects of agency level protests, because otherwise we seem to be blessing the idea that some may not, should not be made the subject of agency level protests. And I don't know if we know that or think that. So if we're just saying transparency, it should just say may or may not.
Okay, I'm okay with that.
I mean, it's minor, but I just don't want it to give the insinuation, I guess, that, you know, some shouldn't be the subject of agency level protest.
Well, I think that, I mean, I don't, maybe that's how it reads. I don't read it that way. I think that we're just identifying which ones, and that's a question we just haven't answered. I don't read a negative inference into that. Anybody else want to chime in on this one? Okay, well, let's do a straw vote here. I'm not quite sure how to do that because I can't look around the room. But maybe, Mark, can you strike out the first and third sentence just so we can see that what that looks like? Okay, and now that we all see this, can you not have this be the full screen so everybody can see everybody now? And then let's just look around the room by a show of hands. Who's okay with this, or who wants to keep the presumption? So I can't see everybody at once. Now I can see everybody at once. By the show of hands, who likes the revised language that keeps transparency but eliminates the presumption? Okay. Who would like to keep it as it originally was? Okay, with the straw poll, we're going to go with the transparency yes, presumption no, and we'll get a chance when we're all said and done. Maybe we'll change our mind, but right now let's go on that. Let's move on to something else. Okay, Mark, can you bring up the full screen for us
Aaron,
again?
can I ask one other question?
Sure. Yes.
So from what I understood earlier, someone from DOD is going to be weighing in. I know we don't have another meeting scheduled on this, but can you just refresh my recollection of the opportunity that we'll have to hear some feedback from the DOD individual?
Matt? Matt, can you answer that question? Or Reeve?
Just to ask a question. I missed the latter part. Just can you just ask it one more time?
Sure. So I just maybe I misunderstood, but if you could just refresh my recollection, I understood that someone from DOD we're hoping would be participating in this conversation. We obviously don't have another committee meeting scheduled. We're hoping we might hear back from them. I'm just wondering if there's a chance we might hear some other substantive input on the merits of this.
Who is speaking?
Sorry, this is Tristan Levitt from MSPB.
Tristan, were you on when we addressed this question at the outset?
I was, and I apologize for raising it again.
I don't know what are you asking that I didn't already address, I guess.
Sorry, I was just asking if you could remind me. I apologize.
Okay, so I mean, I've sent a letter to the Department of Defense, and we have not heard back from the Department of Defense. In particular, our member at the Department of Defense. The committee is going to give them, the Department of Defense, or our member, I should say, at least another week to reply. I don't know what the content of that reply will be. I don't know if there'll be any substantive suggestions and so forth. If DOD has any substantive suggestions or requests, then the committee will decide whether to take them up. If we don't hear back from the Department of Defense, or the Department of Defense says it has no concerns, then presumably Aaron would just take a vote by email. I think that's not. Reeve, is there anything more I can say on this front?
No, I think that covers it. I think that's exactly right.
Thank you for addressing that. It's just helpful to recognize,
Thanks,
regardless
Tristan.
of whatever feedback.
Okay.
Okay, let's go to number 3. We have a should versus might question. And my general instinct is always to go with should rather than might, because everything we do is a recommendation. But here, I think this is actually a different situation. It isn't us just being mushy. We actually think there's a substantive reason for a might rather than a should. So as I understand Chris's point, it is that there's actually reasons why, even in a perfect world, we might not want some agencies to do a should. We'd rather them decide for themselves if it fits within their command structure or how the agency is set up. Is that correct, Chris?
Yeah, and I went back through the report to check on this, and with the lead recommendation in my draft report, Aaron, was that the agency not split the function between agencies, but rather that the agency dual hat, that they have somebody, for example, the competition advocate or somebody in the general counsel's office dual hat and be the APO.
So in light of that, I am perfectly happy with a might, but it's the committee's report, committee's recommendation. So what do folks think? Does anybody oppose a might? Going, gone. All right, let's make it a might. Thank you, Chris, for that. Okay, let's go down to the next one, number 4. And this is going to be for number 4 and for number 6, where we cross-reference other bodies of law. And I think we should treat them the same. Again, this is just my reaction, picking this up and reading this again. What I would like, again, subject to the committee, is I think it makes a lot of sense to put this in the preamble to explain what we mean by how the deadlines work in the Contract Disputes Act, or how they work in the 4 CFR and 48 CFR. Put that at least in a footnote or something in the preamble, and that way we don't need to reference the body of law. We can just say similar to the deadlines under the Contract Dispute Act, or similar to the record as to the GAO level protests, without having to lard it up with legal citations in the recommendation. So that's my preference, but maybe that's easier said than done. So what do folks think?
So Aaron, I went back and looked at the reference, the regulatory reference for the Contract Disputes Act procedures would be in the same part of the FAR, and it would be 48 CFR 33.212. Excuse me, 33.2.
Number 6.
This is it would be under 4.
Okay.
I'm sorry, I misspoke before. It's 33.211. 33.211. It lays out a procedural gateways for the decisions on the Contract Disputes Act.
So let me ask a threshold question. Is there a place in the preamble where we could explain how deadlines work in a footnote, and not have to put them the legal citations in the recommendations? I'm looking if we ever talk about deadlines. I'm sure we do talk about deadlines. But I'm looking.
That's really a question for Mark.
I mean, we have deadlines in lines 32 through 37, I believe, of the preamble. So could we drop a footnote at the end of that paragraph, explaining how those deadlines work? This is maybe a question for Chris. Am I mixing apples and oranges here?
I'm panicking. I'm sorry, Aaron. The answer to your question is there's no reason not to put it in the preamble, and I think that would work fine. I think for the procurement community, Aaron, the cross-reference to the FAR provision would be very, very useful. It's sort of for procurement geeks, it makes the light go on. Aha, that's the procedure they're talking about.
So my recommendation, and I'm going to throw it out to the group here, is because we're not taking the final vote this meeting anyway, how about between now and next Monday, we make sure we have the right legal citations, and we drop a footnote at the end of line 37 that explains what the deadlines are. So we have something that we're referencing in the body of the recommendations, and we just get rid of the legal citations in 4 and 6. And then we'll have a chance to vote on it, hopefully next week, or if not, next meeting. Does that make sense to everybody, Eloise?
It does make sense to me, but in the interest of consistency and just skimming ahead a little bit, I wanted to, and this may be for the next thing, Aaron, you may want to resolve this first, but by way of resolving this, I wanted to just observe that I think in recommendation 9, which we haven't talked about, there's an internal citation, but then in recommendation 10, there's a specific reference to something, but no internal citation. So whatever we do, I think we either want to be consistent or have a good reason for why we're not being consistent. And I know we haven't talked about those two yet, so you probably want to just wrap up where we are now, but just flagging them for consideration.
Yes, keep a pin in that because I want to make sure we're consistent. I think that's really helpful. And I probably think we should resolve them the same way. But first of all, let's do 4 and 6, and then we'll talk about that one. Does anybody oppose to my idea of putting it in the preamble and then just cleaning up the recommendations? I can't read people's faces, so I'm going to go going, 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 gone. That's what we will do. By next time, we will circulate a draft where we'll have proposed language. I don't think this will be controversial, so long as the legal citations are correct, and we'll make sure that they are. Okay, let's move on then to number 11. And this was where we ended last time, and we did it pretty quick. So I want to make sure we feel okay with this. And Joseph O'Connell had some thoughts. We went back and forth. So let me just again say what I think makes sense, but I'm totally not, this is not strongly held, and even what's strongly held, I defer to the committee. I don't know if we need this level of specificity. I liked Ann's proposal to say we should do like what the GAO does, and we can get rid of some of this specifics. I like being a little bit higher level of abstraction. But I guess my question is, maybe this is for Chris, maybe this is for Ann. Would that work? If we took Ann's language of agencies should annually collect and publish data about the bid protests they adjudicate, to the extent feasible, the data should match what the GAO provides about the bid protest it adjudicates, i.e. provides the list of items. If we had that instead of the sub A through F, would that accomplish everything we need in a quicker, cleaner way? Maybe this is for Chris.
Yeah, I think so. I just want to flag for you that there, and this is an important recommendation because I just published on the chat, I published the language from the Senate Armed Services Committee report, and clearly the Senate Armed Services Committee is looking for more data on agency level bid protests, and so the way we frame it, however we frame it, the way we frame it will be an important guidepost for the DoD report that's to issue pursuant to the Senate Armed Services Committee direction. And the answer to your question is that would be perfectly fine, cross-referencing to the GAO, because the GAO is taking a very sophisticated approach. They don't just look at protest 1, they also look at protests to the protests that have been resolved.
So Ann, maybe I butchered what you were saying. I'll let you speak for yourself.
So in a way, what I had initially proposed under 1 would actually list the items, but just without the subletters. So the IE would actually list some of the items that the GAO does. To cut it down, You could change the IE to EG and put maybe 1 or 2 that we think are the most important of the different metrics that the GAO reports. But I definitely think we don't need to list them out kind of with the subletters.
So here's a question for Chris. Are there things that the GAO reports that are not on this list of what we already have of A through F? Or is this just replicating what they report?
I believe it's, I'm not Chris, but I believe it's when I went back and forth with Mark on this, I believe this is the list from the GAO. I can quickly check it, but I think this is the list from their annual reports.
Well, then I'm inclined, again, I'm fine being overridden too, but I don't know if we need to include examples if we're saying exactly what they report. I mean, doesn't that just create confusion?
I'm good with that. I mean, it's clear. I mean, it's clear what they report. I mean, it's on their website. They have annual reports. They have a set of items that they list.
Jennifer?
My concern would just be, what if GAO practices in the future? Right, like let's say we have somebody who heads it that is not as good at providing data. I mean, to that, I don't know, I'm in favor of talking about the substance of what it is that GAO likes that we like, and memorializing it. Maybe we could do both. I mean, if the concern is you want consistency, then we could say, you can get rid of the sub items, but maybe say these things and then say, and to the extent feasible, try to match GAO. But anyway, just like I said, the concern is just GAO changing in the future.
Yeah, then the support for Jennifer's position is that what GAO is really giving statistics on its workflow. What's not in this list is what the Air Force, and I talked about this in the report, the Air Force, which is the most sophisticated procurement shop, they look not only at gross numbers, but they're looking at what kinds of issues pop up on a repeating basis, which is what you'd see. This is really a compliance system. That's what you'd see in a good compliance system. Hey, where are the problems occurring on a regular basis so we can address them from a management standpoint? So this list is probably inadequate. And Jennifer, I think Jennifer's point is a good one, which would be to not make this a complete list, leave it open that there are other things maybe want to be in those report as well.
Okay, I am persuaded. I think Jennifer's point is spot on. So you were right the first time, Anne. What's some language we can use here? Or how should we go about doing it? Do we want to do Anne's language and then with the IE putting A through F in the IE, or do we want to do how Jennifer was saying? If you can remind me again with that, how exactly you said that, Jennifer, I thought it was good.
Well, it's just the idea that, we keep a lot of what's here, and then you could add language if the concern was about consistency that, basically takes what Anne's recommendation here is, and just to the extent feasible, the data should match what GAO provides about the bid protests it adjudicates. I mean, I don't think we have a substantive disagreement. I think it's just like formatting, right, at this point. Like, we all seem to want to say something about matching GAO, and I think we also all want to say something about the substance. And, which order it goes in, I don't think it really matters, right?
Okay. I agree with that.
Fine. I mean, if Anne wants to do it in a parenthetical, I mean, that's absolutely great too. Either.
All right, does anybody want to propose some language for us?
Yeah, I would just make it Aaron, make it an EG as opposed to an IE.
Okay, so you would take Anne's language. Let's just put it on the screen so we can see what this looks like. E.g., okay, and then which one of these would we put in there?
I think if to the extent that we're going sort of with the list, which I preferred and Jennifer gave additional reasons for, I think I would keep the list that we have And I was just suggesting just not separating them out, just putting them in the parenthetical.
With semicolons.
Yeah.
So let's see what that looks like. Can you try this for us, Mark?
And just to add back, I mean, I do think Chris is right that there are agencies like the Air Force that provide much more, you know, that there's more rich information that's provided. But I think by having just some of the basic information is good for transparency.
And while we're doing that, while Mark's doing that, I'm going to throw out an idea to fix the consistency point that Jennifer was referencing. Would it help to put a currently provides between GAO and provides, so we know we're locking it into place and we're not, you know, locking onto whatever they do. We're not saying that we're always going to match, but we like what they currently have, or is that not what we want?
I like the idea of currently. I do think there's less risk of the GAO kind of changing what it's doing. I mean, Jennifer kind of made the comment, what if there's a new leader? I mean, the Comptroller General has, you know, a 15-year term, and so the GAO is not an organization of radical change, except when, you know, a quarter of it was cut in the mid-90s. But other than that period, it's pretty consistent. But I like the word currently.
Jennifer, do you have any thoughts?
I think currently is fine. I mean, if people are worried about kind of having to have people back and look up what GAO was doing at this moment of time, I mean, another thought is we could use the phrase somewhere like at a minimum, you know, to the extent feasible, the data should match at a minimum. Maybe it's just adding that at a minimum with the GM. I guess that's a separate point. So the currently seems fine to me. I mean, and we could also play around with the idea of at a minimum to recognize, I think what Chris was saying, that people might want to go above and beyond this.
That's right, but doesn't the EG do that? Eloise.
Yeah, that's true.
I'm in favor of currently, but I also, in the interest of consistency with the other points and the point I just raised, I think it's nice when you give people an ability to go to the original source. So I would vote for having, where does the GAO provide this? If we're going to put it in the preamble or here or whatever, just going to put a pin in that again before we leave this, that we should have some way for people who are interested and are going to be part of this, but are not deeply immersed, as Chris's experts are, to be able to find where this even is.
I think we could say that the GAO currently provides in its annual reports. I mean, that's what it's coming from. They do formal annual reports.
Well, then that works for me. Thank you, Anne. Does that work for you, Eloise?
Yeah, that is fine. As long as somebody can track down where the source is that we're referencing, I think that works.
Okay. All right. Before we move on to 8, 9, and 10, are there any more thoughts on 11?
Yeah, just so you understand the systems part of it, I think the result is absolutely correct. What happens as a practical matter, Aaron, is that bid protest attorneys want to know what the hot topics are because they want to protest those topics. They're more likely to get a decent hearing. And so having something in the report that says from a subject, for instance, this year we've had a lot of bid protests, successful bid protests involving bribes. Then the next year, the protest attorneys will know to focus on the bribes. It's a way of the system cleaning itself because those protest attorneys will focus on those issues that are of premier management concern, and the law and the practice will develop better. That's why we want to leave open Jennifer's idea, leave open the possibility of reports that go beyond the minima in the GAO reports, talking about where there are issues that are occurring in the procurement system.
So if that's our goal, then I don't think we want matches in the right word. We want something should at least include what the GAO currently provides.
Yes. Perfect.
Does that do the trick for you too, Jennifer?
Yes, great.
Okay. All right, I'm gonna do a going, gone. All right, we'll have another chance before we're done, but let's move on now to 8, 9, and 10, which is our new stuff. Okay. First of all, before we go, I've been assuming everybody can see the text. Is that true? Is there everybody can see the text? Okay. Hearing no objections, I assume everybody's seeing the same thing.
Aaron, can you not see everybody? You can't see everybody?
I can't see everybody when I have the screen of what I can see right now is half of you maybe, very, very small squares, and then I see the screen of the text that we're working on. Is that not what you're seeing? Now I see everybody. Now they moved it to everybody.
I think there's a setting because I can see everybody the same except for they just get bigger or smaller on the screen. So it just might be helpful for you because, for example, you know, you can read people's people sometimes are putting their hands up, not speaking. I'm sorry to speak out of turn, but just there is a, I think there is a way for you to be able to see people.
You can drag the size of the shared screen to the left or right to expand or contract the size of the speakers.
All right, put the shared screen back. Let me see if I can make this work. All right.
We can also see you, Aaron, and how hot you are. If at any point you want to take a break, let us know. This is like a psychological test. What if you saw a law professor dying of the heat? What would you do?
Yeah, no, I'm okay. All right. I can see everybody now. That was very helpful. Thank you, Eloise. Okay, all right. So we're moving on. Jennifer has a comment. Jennifer?
Sorry, this is just on 5, not 8, which is why I just flagged it for Aaron. But my comment was some confusion, to me at least, in the language in the second sentence. So if you just want to slap 5 up for everyone, that'd be great. Whoever's controlling the screen. But anyway, basically 5 says in the second sentence that agencies should clearly and immediately communicate when they have made a decision. Oh, there it is, great. And I thought we should either delete that, we should delete that sentence, and then in the first sentence, maybe change adverse agency action to agency decision. And the motivation just is, first of all, the second sentence struck out to me because agencies shouldn't immediately have to communicate a decision, right? You know, subject to agency resources and all of that. You know, we want to use language like promptly or, you know, when practicable. And I wasn't sure, then it made me read the first sentence and I was confused about whether we were saying it was prompt for adverse decisions and then like immediate for, you know, positive decisions. Anyway, to clear up that confusion, I would suggest striking out the second sentence, like I said, and then, you know, because presumably we want prompt written notice for non-adverse decisions as well, right, Chris? There was something that you were trying to.
Yeah, what we're trying to get at here, and this is a friendly amendment. I agree with you completely in terms of clarifying this, Jennifer. But what we're trying to get at here is that if there's an adverse agency decision, whether or not it's express or implied, that triggers a GAO deadline, and something we talked about in the last session. But the way to answer your issues would be the first sentence would be agencies should provide prompt written notice for protesters of agency's decisions. I agree with you there.
Yes.
And then in the second sentence, to address the fact that the adverse agency action can be a huge sand trap because it can be implied, for instance, by making an award to the competitor. We could say agencies should clearly and immediately communicate any adverse agency action. Because what we want to do is, and we discussed this in the last section, we want to force the agencies to make transparent any adverse agency action. There should be no inferred adverse agency action. By the way, if you don't do that, what happens, what a good lawyer does, they have to call the agency every day. Have you taken adverse action? Have you taken, it's ridiculous process. So if the second sentence remains in, but we say agencies should clearly and immediately communicate any adverse agency action, that will put the onus on the agencies to give clear notice when that happens.
What do you think, Jennifer?
So I think that's good. Sorry, hold on. Sorry about that. I think that's good. I might suggest just one other idea is to take out the second sentence completely and then put written notice to protesters of agency decisions, adverse or otherwise. Again, just to clarify, I'm not trying to make any difference, I think, between prompt and immediately, because I don't think that they can necessarily be made immediately. I mean, it's such just wordsmithing. I mean, but I think nothing is lost by saying protesters of agency decision, just adverse or otherwise. But again, it's more for clarification than I think the substance, I think, is addressed either way.
I'm
I'm
sorry.
going to put her on the spot because I always do that. Eloise, you are our wordsmith expert here. What do you think?
I actually was trying to remember the substantive disagreement we had last time, and I can't remember that. I actually think it was Susan, not Judge Susan Bernard, but the other Susan, who was making some points about immediately. And I believe she was a strong advocate for immediately versus prompt. So actually, I'm not yet up to the wordsmithing stage, Erin, though thanks for putting me on the spot, because I'm trying to recall the substance of that discussion and wishing she were here. Does anybody else remember? We did talk about prompt versus immediate. And I remember there was, Jennifer, I completely hear what you're saying. And I, in general, get the kind of subject to agency resources point, but there was a real reason why she was advocating immediate, some gamesmanship point that I just don't recall the details of right now.
Yeah, it was
Does anybody?
Susan Ebner, who's the chair of the Public Contract Law Section of the American Bar Association, and her concern was that prompt might be read to mean 3 to 5 days. She wants it actually that day, immediately, by an email. That's why she wanted the word immediately.
Yeah, as I recall, her concern was an agency will do this on like a Thursday night and not give you notice until like a Monday. And you've already burned 4 days that you need to, if you want to do something. So I think that was coming from like a practical person in the field.
Yeah.
I don't know if the word, I think the word promptly, my instinct is prompt already does that. If time is super meaningful and you wait 3 days, so it's a material effect on the party, you're not prompt. And we don't need to get into, metaphysics about what's instant and what's prompt. But I don't know, I'm not sure. So Chris, you're closest to this. What do you think?
No, I think it should be immediate is good. That's a clear signal that it can't be 3 to 5 days. And then so the real question is I think is Jennifer's question about whether or not we should delete the second sentence. And I think that the second sentence is so effective in terms of closing the sand trap, making things solid. I would strongly recommend leaving it in as is.
No, I appreciate understanding the background now. And with that background, I now agree. I now see that you are trying to make 2 different points, which comes out with using the different words, prompt and immediate.
Yeah.
It should say adverse decision then.
So would you go back to the original language?
That's great.
Jennifer, would you go back to the original language?
No, I actually like how it is now.
Okay. I like how it is now too. I just want to make sure I'm understanding what you're saying. Okay. All right. While we've got this, we're going to go on to 8, but does anybody have anything you want to add to 5?
And was there not a reason why you preferred in what's now line 110 decision to action? I thought we had a long conversation last time where you were concerned about the agency not getting to determine what constitutes an adverse agency action. And I thought we sort of wordsmithed around that to avoid what it now reads as.
Yeah, we had this discussion last time about not to have the agency make the determination about whether it's adverse or not, just to kind of give the decision incredibly quickly because these time clocks are incredibly short. The judge may have more to say on this, but there was a whole discussion, and yeah, we definitely took out the word adverse because it has a legal connotation.
Well, except for we kept it in at the start of 5. So now all we've done is move them.
I think there's a difference between an adverse decision and an adverse action, because adverse action, the way I understood it from our conversation last time, is a term of art that triggers certain things, whereas an adverse decision, anyway, the way I was reading it here is no, your bid protest is denied. But maybe that's too narrow. Okay, Chris seems to say that's, so then I would just clearly distinguish that in some way. And if they are terms of art, do we need a citation?
I mean, what, instead of adverse, why don't you say if it's denied? Adverse has a whole range of connotations. I mean, I'm a very big one for being very specific about stuff. An agency protest is either granted or denied. It may be adverse in either setting, but I mean, the words or adjectives bother me.
What we're trying to capture, judges, is the non-decision. It's where, for example, if the agency just ignores the agency protest and makes an award, that is in effect an adverse decision. That's an adverse action that would trigger the GAO deadline. That's the problem, and it happens a lot.
Adverse, what you says fails to make. Or does not, declines to entertain the protest.
Isn't that what we have now in the deems denied third sentence?
Yeah, we have
something like that. I hate adjectives. I've been kind of quiet listening to all of this because, there's a lot of stuff in here that I would, if I was a member of the group, technically, which I'm not, I'd probably take a red pencil too. I think the more specific you can be in using, nouns and verbs and as few adjectives as possible, the better off you'll be. But you're going to run right into this when you hear from the Defense Department if you do. So.
If we could go back to what Chris, sorry, there's noise now. So what Chris was saying, my understanding, and again, this is not my area of expertise, but I have read some of the GAO annual reports. And what Chris was saying is that the issue that arises and that gets contractors upset is that a contract is awarded to someone else and they don't find out for several days, the kind of contractor that was not awarded it. And then that cuts in the time. And so the agency might not think about it as an adverse action because they are awarding the contract to someone else. And so that's why decision without the adjective adverse kind of encompasses everything that in the contracting community in terms of notice that they might want. But again, this is not my area.
So what if and I'm just throwing out an idea, what if we got rid of the second sentence, but if our goal is clear and immediate, use the words clear and immediate rather than prompt. So agencies should clearly and immediately provide written notice to protesters of any agency decision.
I like that, Aaron. I was going to suggest something similar.
It doesn't solve Judge Braden's problem of clearly and immediately, but that's for a different day. Concept-wise, does this work for people?
Yeah, the problem is the decision is going to be a decision on the bid protest, and they may not make a decision on the bid protest. So,
but don't we have deemed? That's the next sentence.
Yeah, but that's after. So if in the fifth day they go ahead and make an award despite the bid protest, they've ignored the stay requirement and they've just rolled forward and they basically destroyed the position of the protester. What you could say is, if you want to, agencies should clearly and immediately provide written notice to protesters of any agency decisions affecting the rights of the protester. That would be broader than just the decision on the bid protest. That would include a decision, for example, to make an award.
I have no problem with that. Anybody else? Okay. All right. Going, gone. All right. Let's go down to 8, 9, and 10. And for the intro to 8, 9, and 10, can you explain what's going on with these, Chris, so people have a sense for the purpose here?
Yeah. Well, on one hand, there's going to be a stay of the procurement, but that is probably the most sensitive point for both for procuring officials and for program officials, that they really dislike the stays of the procurement. So the idea is to allow the stay to remain effect, but also not to be disproportionately disruptive.
Okay, so that's at the agency level. We also have a statute level in 9 and GAO level in 10.
Mm-hmm.
So I just want a big picture of this whole section, and then we'll go through all of them individually. But these are all about time, correct?
Time and sequential protests too, how we handle sequential protests.
Yeah. And is this, just for those of us who aren't in this space, is this a serious problem? Is this something that comes up a lot in your interviews? Is this something that people focused on? I'm just trying to get a feel for it.
For the current situation, Aaron, is that it's uncertain enough whether or not you'll get a stay at the GAO protest. The people don't want to bring an earlier protest at the agency. Since getting the contract is the whole game in American federal procurement and federal bid protest. That is the whole game, getting the contract. The chance that you'll lose the stay and the contract will roll forward is an overwhelming risk for the protester and for protesters counsel. So protesters counsel will say, let's not take the risk, let's go straight to GAO. So if we're setting up a sequence here where if you first protest at the agency, you will still be able to bring a second protest at GAO. That's very good. And by the way, the rest of the report and the rest of the recommendations are set up to measure that, because one of the recommendations is that the record that's compiled at the agency level would match the record that would be used at GAO. So if the protester smells something and says, well, I really want to have access to that record, I smell something, I'm going to go to GAO now. There's an efficiency and fluidity to that. My report, by the way, also recommended that at that point, GAO deal with the protests on an express basis, deal with the protests within 65 days.
Okay. All right, with that, I'm going to open it up to the group. Thoughts on, let's go 8 first, then 9, then 10. Thoughts on 8? I see Terrence says that agency stays is a critical issue. Thank you. So just get the ball rolling here. Oh, Anne, I see your hand. I'll let you get the ball rolling.
It's going to be a tension, right, in the recommendations, because ACUS is trying to encourage more bid protests to happen at the agency level. But by having longer stays, that makes them less attractive to the agency. I mean, this is one of the big kind of incentive issues when, as I understand it, disappointed contractors are choosing between going to the GAO in the first instance, where you're going to get a stay, or going to the Court of Federal Claims where you have to ask for a stay.
Right.
Yeah, so Anne, that's very similar to what I was going to say. Again, we were talking earlier about number 1, about a presumption, whether that would be controversial or not. And I didn't know, but I would think this would be much more controversial than that. Number 8, changing stays and things of that sort. This is getting into the structure of how this thing works. It's not just transparency, this is changing operation. And that doesn't mean it's not good. It just seems like this is one that we got to be right on, because there's more meat on this one than some of the others. So I'll throw it out to you, Chris. This is just a question. Like, how disruptive would this be for agencies?
So paragraph, just focusing on paragraph 8, Aaron, this is an idea. Right, yeah, we picked up this idea from the Department of Labor. Ben did a lot of the initial research on this. Ben's on the line with us. And this is Department of Labor automatically extends for 5 days. I don't think the agencies would consider a 5-day extension after the decision to be truly disruptive. And that gives the protester time to go to GAO. Okay.
So would it be helpful? Again, I'm fine with temporary. I think, again, I don't like micromanaging, and these are all recommendations anyway. So it's up to the agency to decide what these things mean, to the extent they want to do what we recommend. So they can say what temporary means. But playing devil's advocate here, would it be helpful to put a 5-day extension? Would that be more specific, or would we just leave it at temporary?
I think if you said e.g. 5 days, you're clearly signaling that you concur with the Department of Labor's approach.
I see Anne is asking a similar question. What do you think, Anne?
Maybe you indicate short or give an example of 5 days, but that makes me feel better because when I read that, I didn't think 5 days.
So if we were to say replace temporary with short, and then we put, after that, e.g. 5 days. Well, we have the next sentence that says what the purpose is. Well, let's just change the next temporary and the next sentence to short too, so we can look at it together. Eloise?
Once we're giving the purpose in the next sentence, why don't we move the e.g. 5 days into the second sentence? So delete the e.g. 5 days there and then put it after should be of sufficient duration to give the purchasers parens e.g. 5 days. Otherwise the 5 days feels floating and random to me in the first sentence.
So after sufficient duration, parentheses, e.g. 5 days.
I might even put it later, like at the end of the sentence, but this is more wordsmithing than substantive.
I already said you're our wordsmith person.
I know. Feeling a little self-conscious about that, Aaron.
Anne, what do you think? Is this giving you heartburn? Judge Braden, what do you think?
You want to restate your question for me? I was sitting here looking at my inbox. I'm sorry.
Sure. Okay. So we've replaced short with temporary with short, and we've said e.g. 5 days, so we don't scare off agencies by making think we're asking for more than we are.
Yeah, I mean, look, it is what it is. I mean, they're going to have to come up with rules internally anyway. So, and they're going to have to be specific. You can't say short, medium, long. I mean, that's, you're going to have a time period someplace. So this is fine for now. I mean, it's not going to, they're going to have to issue some type of, internal rules that are going to be, made available to the public. I mean, you can't use these adjectives. There's no measure for anything at that point. I mean, what's the remedy really here for the protester that loses? There's no remedy other than to try to go to the GAO and to the Court of Claims. Now, the Court of Claims does not give deference to the GAO as a matter of law. But, look, they got their finger on the scale as a practical matter. So, I mean, the litigant or the protester is taking a risk, it seems to me, because if he gets an adverse or he or she gets an adverse opinion early on like this, it's likely that they're stuck one way or the other. Do you see?
Yeah, no, that's right. I mean, our goal here is to make them a little less stuck.
You're gonna have a tough time doing that. I mean, unless this is integrated in some type of other larger picture, which I guess you're going to get to in a minute or two. But I mean, it's a good idea. I understand what you're trying to do at a macro level. It's a good idea to do this, but put yourselves back in the hands or the shoes of the person protesting. What do they gain by going to the agency? They get a quick decision, and they may be fine with that. Tails I win or heads I lose or whatever it is, and that may be fine. But they're pretty much their fate is going to be probably sealed by going to the agency of the state, and that's a value judgment they have to make. You see, I mean, that's a value judgment they make when they go to the GAO. We have a lot of times that they start at the GAO, they get the automatic stay. They use the time up a little bit, and then they tippy-toe out and say, oh, never mind, and then go to the court. That's not necessarily a bad strategy. It buys them some time under the contract. But, and, you know, the judge, I think the judges kind of understand what the game is there. But in the end, you know, if the GAO issues an adverse decision, while it is advisory, I suppose, you know, in reality, a lot of times it becomes the end game. I'm not saying that should happen. I have taken a different tact in one particularly large case where I thought the GAO really made a huge mistake, and later on they came back and said they did. But on the whole, you know, you need to understand what you're selling here is a process. And the question is who wants to, what's the advantage to someone taking up this process versus the downside? It's just the way it is. I'm not saying it's not a bad thing to do. It's just, it's going to have risks in it for the person filing, aside from whatever the agencies, the Defense Department folks have to say. And I mean, they're not going to want any more. They would probably like this if the GAO and the court were taken out of the picture. I mean, they would wholeheartedly endorse this approach. But if you're going to have three levels, I think they're going to, you know, fight you tooth and nail on it.
All right. Well, we're now at an hour and a half. What I propose.
So if you're 5 days in, but it's not going to make any difference. You see what I'm saying?
Well, we're going to take a 5-minute break, and then when we come back, I want to hear Chris's response to that. So let's take 5 minutes. Let's be back at 3:35 Eastern, and we'll hear from Chris to respond to Judge Braden. Thank you, everybody. 5 minutes.
Can we just stay put?
Yeah, you can just stay put. You can just stay put, but some people would like a break. Thank you. How are you doing, John?
Sorry, I was off there.
So are you in DC now? Where are you?
I'm in DC. I was going to go up to New England, but the governor of Massachusetts slapped a 14-day quarantine obligation on anybody coming in from down here. So I'm staying home.
How are things?
Extremely quiet down here.
And you, Matt, where are you? I scared him off. He disappeared.
He's not there. He's an avatar.
No, I'm here. I'm here. I'm in Virginia, and I don't really leave Virginia.
So my kids, they're so tired of coronavirus because we can't go anywhere. But I tell them, just be grateful you're not in Washington, D.C. right now, because we can at least go outside in the mountains and go hiking and go fishing, and not see anybody. We're okay. But what do you do if you're in a city?
You have Rock Creek Park.
Yeah.
And we live by the park. It's lovely. We walk up there every day.
We live on Capitol Hill, and I make my kids go for a walk every day, and they are not happy about it. My daughter in the kitchen chimes in, I hate it.
Are you going to be able to put your kids in school at the opening of the year, Aaron?
Yeah, that's the plan in Utah, is that kids are going to go to school with masks. We'll see if that really happens. Okay, it is now 1:30 or 3:37 Eastern time. Chris, you heard some thoughts from Judge Braden. Curious about your response, and then we'll jump back in.
Yeah, I think the essence, as I understood what Judge Braden was saying, the essence of it is that the agencies are going to be very reluctant to accept a solution that creates a chain of stays that holds up the procurement for a long period of time. And I agree, that's a practical problem here. What we tried to do in the report and through these recommendations for the 3 paragraphs is knit it together. Say, yeah, you can go to the agency first. Yeah, if you do go to the agency first, you do get an automatic stay at GAO afterwards. But the GAO should deal with the protest there on an expedited basis to keep everything within the 100 days. The 100 days is generally accepted as an okay period of delay, and that normally a GAO protest can be done within 100 days. What we're trying to do is match that with a agency level bid protest in 35 days and a GAO protest in 65 days.
Okay, so I agree. Just for what it's worth, as I hear the conversation, I'm very sympathetic to Judge Braden's concern because I suspect that we are going to get some pushback about a series of stays. That said, to go back to how we started, these are just recommendations, and sure, people might not like it, but if we think it's the right answer, we should say that's the right answer. And what are they going to do? And if they feel strongly enough about it, they won't do it. But I don't see a reason why that keeps us from saying what we think the right answer is, and then let them not do it. But I think we defeat our purpose if we fight against ourselves. So I'm inclined to say if we think it's the right answer, to do it there, let things fall where they may, and if they just don't like it, they just won't do it.
Yeah, and I would unpack it backwards, Aaron. Let's say you're testifying on the Hill, and you're talking or testifying to support the ACUS recommendations. Yeah, I think the ACUS recommendations can fairly be presented, including these paragraphs 8, 9, 10, as a way to make agency level bid protests work. And we think that agency level bid protests are the best possible outcome for an agency. We want to make them work because they're very good for agencies.
Jim Tozy.
I just want to make one comment on ACUS recommendations. I don't know how the agencies take them, whether they can violate them or not. but there's a number of people, practitioners such as myself, that will go through the record and use an ACUS recommendation to move some agency in the direction I want them to. For example, I'm working on an issue where ACUS came out with recommendations on limited interrogatories during adjudication, and I'm moving it into the rulemaking process. So quoting ACUS recommendations, at least to me now on the outside, is very important. So I'm not sure they may not be completely up to the agency at times to ignore them if outside groups press for the agencies to abide by them.
Well, that's all the more reason for us to get it right.
Right.
Okay, let's look. Do I hear any more responses to 8, or are people okay with 8? If not, let's move on to 9. And as I heard you speak, Chris, you mentioned deadlines in your report that we don't have in the recommendation. Am I misstating what you said?
No, no, I misspoke. I'm sorry, Aaron. What I alluded to the recommendation, and I was talking about what is in paragraph 10, and it's paragraph 10 tracks what's in my report, which is a recommendation that the GAO protests be dealt with on an express basis. One of the problems with dealing with pushing GAO into that express channel is they say, wait, we need to have enough time to have the agency assemble and digest the record. Well, per our other recommendation, Aaron, that record has already been assembled for the agency level bid protest. There's no logical reason not to spring into an express action at GAO.
Let's talk about 10 first. That's a good point. We'll reverse it. We'll do 9 last. Let's do 10 because you just went there. That makes sense to me. But what do I know? What do folks think about that? And then we'll talk about what we're going to say to Congress, if anything. Looking around, Anne.
I apologize if this was said before, but have we asked GAO about this?
So
Matt, let's let Matt and Reeve and Mark. We haven't spoken with GAO, have we?
I heard the part about the Defense Department, and I apologize if this was covered.
I don't think we've consulted with GAO.
Mark, has GAO been consulted on this particular point? GAO is certainly on notice and has that we are working on this recommendation, has been invited to all the meetings and so forth and so on. And I believe GAO is aware of the content of the draft recommendation. Mark?
So I trust that this is what Chris was about to say. In the course of compiling his report that's the basis for these recommendations, he interviewed a number of officials at GAO. They were the ones, I believe, and Chris, you can provide more detail about this probably than I can. Did you ask them specifically about the content of what is now recommendation 10?
No, I didn't. You were in the room, Mark. We didn't, because we weren't at that point in our analysis yet. But I did share the report with Ken Patton and with Ralph White, and I've not gotten feedback from them on that.
Okay.
10.
Jim, can you repeat yourself? Jim Tozy?
Yeah, could I have a question on 10?
Sure, take it.
When I read the report, is there data in there in our report? Because this suggests that maybe GAO is not doing as much as, and I thought they get around what 2,500 protests a year. And the question is, was there information that they need us to push here? That they weren't doing it on time?
No, the problem isn't that they're not doing it on time, but my experience, I've been doing GAO protests for 30 years. I've never had one done on an express basis. But if GAO doesn't do them on an express basis, you'd have a 35-day or 35-day agency level bid protest plus 135 days of delay. Whereas if GAO exceeds to doing a follow-on protest on an express basis, you're still within the 100 days, that original 100 statutory days for GAO protest. So you're not, in practical terms, you're not causing any additional delay to the procurement.
Well, then someplace in the report, I read this statement. The reform suggests here a rule extending the stay of the award or performance during a follow-on protest. That doesn't abide. That isn't relevant here.
Yeah, that is relevant, but the stay of the procurement is something the stay of the procurement while a protest is pending at GAO is done by statute, and it's separate from GAO. GAO, in fact, GAO will not rule on that question. That's a question that has to be brought to a district court if the stay is ignored.
Okay.
So my reaction to 10 is it makes sense to me as a rule, but I can imagine cases where it actually would be really hard to do on an expedited basis. So what we sometimes do in cases like that, where we think it makes sense in principle, but not in all applications, is we throw in to an extent feasible. Would it make sense to say follow-on protests at GAO are handled on an expedited basis to the extent feasible?
Yeah.
Would that be helpful? Would that be consistent with what we're trying to do here, Chris?
Yeah, and it clearly leaves it to GAO to make that decision whether or not they want to take an expedited to deal with it on an express basis. By the way, I put the rule on express into the comments.
And is that giving you heartburn? Okay. Anybody else want to chime in on this one? Okay, if not, we're going to talk about number 9. And number 9 is a recommendation to Congress. And I'm sure we've done it before. I've not done it in any, at least I don't recall doing it in any of the ones that I have been committee chair for. Maybe this is a question for Reeve. Reeve, what is our general philosophy on recommendations to Congress?
There's nothing against making recommendations to Congress. We've done that in past recommendations. You know, we try to be, of course, solicitous and not try to stay away from anything that we think would be problematic. But as a general matter, we definitely have made suggestions to Congress in past recommendations. Recommending statutory changes or that sort of thing. So certainly no rule against doing so.
Okay.
Aaron, not only is there no rule, our statute affirmatively says that that ACUS is authorized to make recommendations to agencies, the President, Congress, and the Judicial Conference of the United States. So the statute expressly contemplates recommendations. It's just a matter of committee prudence and discretion.
Okay. All right. Well, thank you for that. I will say I don't have a problem giving recommendations to Congress. As I read it, it seems I'm not sure I need to give them recommendations as to where in the U.S. code they need to put things. So to go back to Eloise's point about citations, I think it would make more sense to say something like Congress should enact an automatic stay of the procurement decision if a protester promptly files a GAO protest after an adverse decision in an agency level protest, and getting rid of amending the statute to trigger. I would just say Congress should enact an automatic stay and let them decide how they want to codify things and things of that sort, which feels a little bit micromanaging from our perspective. But maybe I'm missing something, Chris. Is that key language in what we have here?
No, logically speaking, it's probably going to be done within 31 USC 3553. But that's absolutely fine if you don't want to include that reference there. Everybody knows what it means.
Is that a positive law title or no?
Not sure.
Another reason to avoid the specificity there. Thoughts? Eloise.
I guess I don't really understand why this one is addressed to Congress. We also could address this one to GAO, right? This could just be done within the rules.
No,
is there a reason why?
GAO takes the position that for constitutional reasons, it lacks the authority to tell an agency to stay because it's an arm of Congress.
Can you just
why? Can you say the last part again?
I don't understand the because part.
Sure, because GAO is an arm of Congress and therefore part of the legislative branch. It lacks the the authority constitutionally to tell an executive agency to stay a contract.
Oh, so maybe I had misunderstood the stay provision that we talked about in 8. So isn't there a second stay that isn't there some debate about whether GAO does or does not give a stay? I thought that was what was being determined here, that GAO sometimes but not always gives a stay. I thought there was some time period, and that was part of the delay concerns we were having, or that that the protesters were having.
So the idea would be to create an unbroken chain that you would have an automatic, you would have a already FAR-based stay during the agency level bid protest. You have a tail on the dog, which is the additional 5 days from the Department of Labor. And if you file a protest, then that 31 USC 3553 should be amended, that if you file during the tail during the tail of the dog, that you again, then that triggers another stay at GAO while the protest is at GAO.
But when the protest is currently at GAO, is there not a stay of the decision?
Yes, there is. Under 3553, there is already. 31 USC 3553.
So this is just an extension of the period. Okay, I follow you now.
Okay. You want to break it unbroken? We want an unbroken chain.
So if that's the case, that's a helpful clarification, we would need to give a duration of the automatic stay if we're going beyond what 3553 already provides. Correct? Or am I just misunderstanding your exchange with Eloise?
No, that's correct. You could just say Congress should enact an automatic stay of the procurement during the pendency of the GAO protest.
So what does the current 3553 already provide?
There's a stay as long as you bring in, and I've included the language here, Aaron, in the comments from MoFo. I pulled at random a practitioner comment from MoFo, and it's so if you bring a protest within 10 days of award or 5 days after the debriefing, and so essentially we're under 3553, we're putting in a third basis for automatic stay, which would be if you bring another protest to GAO after an agency level decision. Because the 10 days after award or the 5 days after debriefing have passed long ago. The agency level protest takes 35 days to resolve. So that 5 and 10 day periods, those are long gone. That's what MoFo is saying.
Okay. All right, somebody else? Any thoughts on this one? I mean, so this is, I mean, at this point, I confess this is beyond my knowledge. Chris, does this language that we have, would that accomplish what we're trying to accomplish? We don't need to have it. We don't need to have a durational limit in there. We don't need to say how long the stay is. It's just assumed that it's during the duration of the proceeding.
Well, you can say Congress should enact an automatic stay of the procurement decision during the pendency of the GAO protest. During the pendency of the GAO protest.
And is this going to radically change how government contracting works? My sense, again, as somebody who doesn't live in this space, is this seems like the biggest change that we're talking about. But maybe I'm wrong. Is this something that it isn't a huge change, or is this the most important of all of the, at least in real world effect, the most significant of all the recommendations?
So the goal is to make an agency level bid protest just like just as good as a GAO bid protest, and just as safe and just as secure, in order to guide protesters into agency level protests, because they're much cheaper and they're much better, cheaper for protesters, better for agencies. The dark vision here, Aaron, the scary thing here is let's say from an agency standpoint, is that we've taken a 100-day delay and made it a 135-day delay.
Mm-hmm.
That's
Correct.
the scary thing.
Correct. That's what I'm talking about. Is you just changed how this stuff works, not at the margins, but in a significant way. Like you've changed the nature of the beast.
Yeah, it's almost impossible to put agents level bid protests and GAO protests anywhere near the same place unless we tell protesters they can get what they really need ultimately, which is the contract. Now you may say, well, why do we have to have a 135-day delay? The answer is that a protester will smell something during the agents level bid protest and then say, oh my God, I don't have access to the record. Now I have no way of getting a fair hearing because I don't have access to that record unless I go to GAO. If you unpack it all, Aaron, the real pressure point is on GAO. Will GAO say, no, go to hell, when we say you really should be using express protests after an agents level protest? And I don't know what Ralph and Ken will say to that. I like them, but they may tell me to go to hell.
Reactions. There's a lot of smart people in the room. What do we think? John, can I call on you? You live in Washington, D.C. This is your world. What does your gut tell you?
What my people on the procurement team at Venable told me, that this is one of the two issues that really makes them reluctant to use the agency level bid protest. The other is there's no record. But the first thing that came up in the discussion was the date at GAO was so obscure we don't know what to do. We're afraid that we might inadvertently get the client cut off if we don't act rapidly, and that would, I think, as I said at the last meeting, it might be the kind of thing that you lose the client and it can prompt a malpractice action. So I think we have to provide, I don't know if you've got anything like this from the fellows at MoFo, but we need to provide the lawyers who are running these matters some degree of confidence that they understand what the actual deadlines on their actions are.
Okay. Any from the professoriate want to chime in on this one? Look, I mean, I've already confessed my ignorance. This is not my space, so I don't have a feel for the road. Usually when I do this, I just have an intuitive sense of how it works. Here I do not. I've read the report. I think the report is very good. I'm hearing from John that this is what his people are saying. They need something like this for this to be viable. So I think to the extent that Congress wants this to be viable, I think it's a fine recommendation for them to make. There's a big policy question that I don't know the answer to, which is that really the best world? And I do not know the answer to that. So my recommendation would be to go with the expert. We have two on the line. They say this is necessary, and if Congress doesn't want it, Congress can say no. But this is a prudential call, and I confess that it's beyond my expertise.
I think that as a practical matter, this will be taken up by the DoD report the Senate Armed Services Committee is calling for, and then the DoD in turn would put pressure onto GAO to accede to a compression of the protest timeline.
Okay, we're going to move on from this one, unless I hear anybody want to chime in.
And Aaron, I should just say that this is, protest. This whole area of law is still very plastic. It really arose in the latter part of the 20th century. It's changing. For example, there used to be protests of information technology procurements that took only 45 days, and at the General Services Board of Contract Appeals, that jurisdiction was eliminated because that was considered a failed experiment. A lot of these are incremental changes to see if they work, and then we move on from there. It's an interesting, it's changing all the time.
Okay, going. All right, Judge.
Now, I was going to ask you, Professor, are they only talking about, I have sent you a question before, I'd like to see what the language is in the Senate or the Armed Services report, but are they just talking about doing this with the GAO or also with the court?
Judge, I put the language into the chat. I put it in at 254. That's the language from this. It's a Senate report.
I haven't looked at it.
And I put also something on my blog at publicprocurementinternational.com. The first entry in my blog has both the Senate report and all background links as well.
Great, thank you.
Okay, gone. All right. What we're going to do now is we're going to go through the preamble, which I believe will go a lot quicker than their actual recommendations. Mainly what we want to hear is if there's anything egregiously wrong, speak up, or if there's something that no longer matches what the recommendations are, speak up. But I don't think we need to worry as much about the, the phraseology. Subject again, it's your committee. And we'll do that. And then once we've gone through that, then what we will do is we will give everybody, a couple minutes to review it, and then we'll be done for today if no one has anything else to say. So let's start with paragraph 1 and see if anybody, this is how I think we'll do it. If we were in the room, I'd do it better. But we're going to look at a paragraph 1. Everyone's going to read it. I'm going to be looking around, and if you have something to say, raise your hand. If not, we will go on to the next one. So let's start with paragraph 1. Everybody hopefully has it in front of you. If not, it's on the screen. Read it to yourself. Take a few, 30 seconds, and then I will scan the room, and we'll decide if we need to stop and talk. Okay, I see nothing. Anybody see anything? If not, let's go on to the next one. We'll do the exercise again. Eloise.
So I think it would be valuable, and the end of this paragraph might be the place to do it, to say something about the value of the bid protest process, period. So in a couple of paragraphs, we say something about the value of agency level protests, but I come from the federal grants world, which doesn't have this kind of process. And so my instincts are sort of almost backwards from the contract procurement side of things. And when we first met last week, Chris, you spent some time talking about restoring public faith, why whistleblowing is important, how it's different from harassing. And it just struck me that we haven't really motivated why the system is important. And so that at the end of this paragraph, it might be valuable to have 2 or 3 sentences that say something about why bid protests are important to the system at large, to the public, to the functioning of government, et cetera.
I think that makes a lot of sense. I see no objection to it. I don't think we need to draft those right now because we have the fortune of having another go at this. So between now and then, we will do some proposed language along those lines to explain how this thing works. And if people don't like it, we'll vote it out then. Okay. Any other thoughts on this one? All right, let's go to the next one. I know it's an odd way to spend an afternoon, but let's do it this way. Jennifer.
Yeah, this was the question that I had when I was reading through it. I think it's more of a footnote than necessarily the text, but I, as a reader, just wanted to know the interaction between these 3 fora. For example, and I think the answer is no, but Chris, it'd be worth clarifying for the plenary. I wanted to know, is there any kind of like claim preclusion like thing where, if you do bring in the agency, I mean, I know the answer is no, but, similarly with the GAO and the Court of Federal Claims, like if you do bring it in the GAO, does that mean you can't bring it in the Court of Federal Claims, or do you just have bites at all these apples? you could just clarify the interaction between them, I think that'd be really helpful.
Sure. The probably most important is if you do bring a GAO and then you or somebody else brings something on the same procurement to the Court of Federal Claims, GAO will dismiss it.
So that would be really good background, I think, having the footnotes, if not the text.
Mark, can you make a note of that we will add that thought as well for next time?
I thought that you could use all of them. There may be, you may want to rush something. So if the GAO hasn't ruled, you would go to the Court of Federal Claims. But there's a lot of kind of picking and choosing, and the kind of game theory of it all is pretty fascinating. So yeah, I mean, it's not in there, Jennifer. So yeah, I would definitely put a line about how the different procedures, there's kind of a bunch of picking and choosing and kind of strategic action that happens.
Okay, and we will have language to that effect that we will circulate before we vote, and we can go back and forth on. Thank you. All right. By the way, just as an aside, this is what's so great about ACUS is, so I've looked at these recommendations during the kind of the pre-committee process, and at this point, I am blind to them. So I welcome folks who are looking at these with fresh eyes. This is really helpful information. So thank you so much for that. Let's jump on, let's do the next paragraph here, the agency level protest paragraph.
So just so you're aware that in the last sentence, the GAO had a downtick last year in terms of the total number of protests.
But is it a downtick from an already very high number?
They have it's downtick from a consistent number. So I think they lost like 15% last year. So we can just say reducing the likelihood that protests reducing the likelihood that protests will overwhelm those institutions. I think that's fair.
Okay, no, I see what you're saying. Yeah, without objection. Oh, Eloise.
Oh, no, I have no objection. I was going to make one other comment.
So without objection to that, I think that is a very friendly amendment. I would delete the word growing there if it's in fact not growing. And Eloise.
Just in the spirit of my other comment, it seemed to me when I read the topic sentence of this paragraph that there was no room for the public. And since it seems to me, just what is the whole point of this for? So if there's something specific about ensuring fairness and what you said at the beginning about, or a few, I don't know, many hours ago at this point, but about accountability for every federal dollar spent, it just seemed to me that in both the general sense of bid protest and specifically here, there might be some point about about the value to the general public that we might want to make.
So before contractors, we could say the public, which I think your point is very well taken. I think that the goal is if you have a competitive bid process, you pay less federal dollars, which means there's more good for the public to have resources for. So I don't think we need to go beyond that, but I think we certainly should say it.
Agreed.
Yeah, it's kind of two-sided. So always, on one hand, these are incredibly non-transparent processes, so no one knows about it. Like there were 3 agency-level protests in the current Amazon.gov procurement, $6 billion procurement. No one knew about them. They slipped out at a congressional hearing. So they're very non-transparent. So the public doesn't have any insight. At the same time, though, you're really speaking to my heart because there should be citizen standing within. I'm hoping by the time I leave this vale of tears, there is citizen standing for protests. In the nation of Georgia, they do have citizen standing. You and I could bring a big protest in Georgia. If you have a system that's more transparent and more acutely sensitive to corruption, then you will have citizen standing. And I think that may well happen in the coming years.
Okay, any other thoughts on this paragraph? All right, if not, let's go to the next one, vendors. Eloise.
So this may cross the line into wordsmithing, Aaron, which you cautioned against, but later.
I said you're the
So
words.
I know,
You.
but now you've tarred me with that, and so I'm super self-conscious. But at the end of the preamble at line 73, we highlight that all of our recommendations are going to go to the consistent themes of transparency, simplicity, and predictability, which made sense to me when I read it, but we hadn't articulated those as themes at the beginning. And so it just struck me that if that actually is the core of what we want to be saying, we could here identify that those are the three themes that all of these reasons like push back against, and that therefore reasons why vendors don't currently bring them in this forum push back against, or that or describe these reasons, and that all our recommendations go towards. I am not at all wedded to that, but it seemed inconsistent to me and like a valuable aha moment when I got there at the end of the preamble.
So what would you propose? Just again, just off the cuff.
Well, I would propose, I mean, you'd maybe have to do it in a couple of ways. So in line 26, that last sentence might say something like, there are several reasons why vendors may forego agency level protests, comma, all having to do with the themes of, or variously having to do with the themes of transparency, simplicity, and predictability, or something like that. That's a little clunky, but then we highlight 4 reasons, 4 problems that are keeping people out of it. And so to the extent that each of the 4 things goes to one of those things, we might label it as this is a transparency problem, or picking up on the theme of transparency, or something like that. It just might make the recommendations cohere rather than kind of pile on.
Thoughts? I don't like variously having to do, but that is wordsmithing that we can fix by next time. Mark, if you could highlight that clause, that we can come up with a better phraseology for.
So, and Aaron, in this paragraph, maybe one where, do you want to cross-cite to the fact that the Senate has called for a study of statistics? Armed Services Committee?
That's a question I throw to Mark or Reeve. How do we typically do that? I've always thought of us as kind of standalone, and we don't reference other things happening in the world. But maybe that's not true. Maybe we should mention that Armed Services is looking at this stuff.
Reeve, I'll defer to you. You have more experience with this than I do.
Yeah, I mean, I think that would generally be somewhat unusual to refer to something that's in flux like that. I can't think of any prior instance in which we've done so. That at least would be my take. Matt, I don't know if you have any further thoughts on that.
I mean, my initial thought on this, I mean, I think there have been times when we've referred to pending legislation for and other congressional activity for one reason or another. I would suggest that the committee actually review whatever documentation might be cited before we start throwing it into recommendations.
Well, that's certainly prudent. But my instinct is more conceptual. I like to think that this is a standalone document that doesn't exist outside of itself. I kind of like it as these recommendations stand the test of time. And again, this is just me as the academic now. Jim talked about how he uses recommendations. How I use recommendations is I pick them up from like 1975 and read them. And I like to be able to know that I'm looking at kind of a self-contained universe. So my preference would be to say, look outside of it. This is a standalone document, and though obviously the plenary it might come up that other things are happening or whatever, the document itself I think should kind of speak for itself.
That's sort of my reaction, which is you can handle this in your opening presentation. Say this is a matter of some interest these days because Congress is considering it. If this will be something for the next Congress and won't be resolved in this Congress.
So I say let's not add that thought. Does anybody disagree? Reading the room.
I think you're right on this. I think you're right on this, Aaron. It can always be, if something happens in the interim, it can always be addressed.
And then the council always just puts new things in anyway. So we'll, I can laugh at that. Matt can't, but I can. All right.
Well, we won't call it to the council's attention, so it won't get in.
Okay. All right. So let's look at now and go back to Eloise's point. I like the coherent tying it together. I think that makes sense, though we'll make sure that we have a better phrase than, you know, various having to do with, like, but we'll come up with something. I like that though as thematic. All right, let's look at first, paragraphs first. All right, I'll turn it to Eloise, but before we do, one thing I think would be helpful looking at this is a cite to the report. So it's not just the committee just saying stuff, but we have citation where people, real people in the real world have said that they're concerned about bias. I think that it takes the edge off of it a little bit, and we can do that easily. So assuming no objections, I propose we add a footnote where we just a reference to the report. Okay, I'm sorry, I cut you off, Eloise. Take the floor.
No, I was going to say something very similar in all of the each of these rationales we give for why vendors are might shy away. I also wondered whether the verb tense might shy away. Like, don't we know? We've done research on this. So I was a little, maybe the citation picks it up, but the might still strikes me as wishy-washy. It also, in a related way, I wasn't totally sure why we were taking the perspective of the vendor as opposed to ourselves saying one way or the other whether these things were biased or opaque or whatever. It seemed to me that we could be more affirmative on our critiques that are, because if it's just like vendors might think this, but it's really not true, then the result would be we should educate vendors how it's really not true. But if we're actually going to be proposing changes, then I both am a little bit uncomfortable with the might, but also the distancing ourselves from critique.
So I'm very sympathetic to that. I'll let Chris tell me if I'm wrong. I don't know if the report can give us the data that they actually are biased. I think our report can tell us that one reason people don't use this level of protest is because they fear that they are biased. So I don't know if we have the data to say that they are biased, and I don't know if we have the expertise. Sometimes I'd say, well, who cares? Like in the room, we have the expertise. We can just say things. I don't know if, for this question, I don't have the expertise to say whether they are biased or not. I can read the report and says people say they are, but that's the extent of my knowledge. So Chris, is that fair, or what's your reaction?
Yeah, the reason, well, so yeah, there is no data that would show that they are biased. But this goes back, what we're really trying to do is frame up the game theory or the strategic behavior that Ann was referring to before, that contractors and the lawyers will figure out which forum they want to go to based in large part on perceptions of bias, for example, or unfairness. That's why we look at this, Eloise, through the vendor's eyes.
So then do we need to say might? It's the double whammy. And I think actually it might be different for each of the 4 points. Like I think we could more confidently say that the processes are opaque later than that the processes are biased. That seems totally reasonable to me, that we make a distinction from the vendor's perspective versus the rationale perspective. And I do understand the value of doing it through the game theoretic lens, but if part of the point is to show that there actually is a substantive concern that we're addressing, and it's not just that educating vendors that their concerns are wrong, then we might want to be just really specific in each, kind of just attend in each of the 4 rationales, whether we mean might and whether we mean to be distancing ourselves from the substance of the concern. I'm prepared to believe in this first one that we, on the second thing, that they perceive them is the right path, but I'm not totally sure yet that the might is accurate here. Do we not have something in the report, I mean, that says that they perceive them this way?
Well, I say, so you're saying first vendors, you want to say do shy away? That's supported by the report.
Yeah, or some vendors report that or something like that. Yeah.
Could we
If
say
that's supported by
some
the report, then I would.
report shying away from with a citation to the report?
Yeah.
Did you catch that, Mark?
No, Aaron, you cut out on me for a second. Can you repeat that?
First, some vendors report shying away from. With a citation to the report. Does that give anybody heartburn? Okay, I like that more. It works using the report, which is why we have the report, but it also avoids the fiendish ambiguity of a might there.
It's page 23, Mark.
Okay, all right.
Thanks, Chris.
Let's go on to the next paragraph. With the idea, I think we're going to probably change all of these mights along similar style. Okay, so I'm inclined to, along what we just said, to say, second, some vendors report that they view agency level processes as opaque. Again, with the citation to the report.
And I should be clear in there that I was interviewing counsel for vendors, not actually vendors themselves.
Yeah, I think there's a close enough nexus between counsel and client that I'm okay with that, but thanks for the clarification. All right, beyond that, what else do we think? Does this work? Is there any concern? Maybe people who know more about the FAR than I do. Is this accurate? Any concerns? First of all, Chris, you agree this is accurate?
Yeah.
Words like nothing scare me, but I trust the expertise in the committee. Okay, gone. Let's go to the next one. Third. Okay, while people are reading, Mark, can you update the first part of it so it's the same? Vendors report being dissuaded, or some vendors report being dissuaded by, with the citation, which we'll add. Okay, other than that, any concerns, any heartburn, any suggestions? Looking around, seeing none, let's go to finally. And again, while we're doing that, Mark, can you conform this one to the others? So this is a question for Chris about the report. The last sentence we say, this may prompt some vendors forgo agency level protests altogether. Could we be more aggressive with that and say this does cause some vendors to forgo agency level protests altogether, or is
Yep.
it better to leave
No,
it with
absolutely.
the ambiguity there?
Absolutely.
So this causes some vendors, and we'll have a citation to the report.
I mean, just for you, Aaron, and for others from ACUS who may be participating in the process with Congress to understand a couple things here. First of all, the bar doesn't actually like agency level bid protests because they earn so much less. You can do an agency level bid protest for around $25,000 to $50,000, whereas a GAO protest easily 150 to 200, Court of Federal Claims protest easily 200 to 300. So agency level bid protests, bad news for the bar. That's why they're good news for the agencies, because they reduce costs overall to the contractors. The second thing is, just so you understand the overall picture, this idea that in a different part of the report where we recommend that the record be produced and structured as it would be for the GAO protest, even though it's not produced to the protester, makes things reduces risk substantially for the protester. Because if the protester can meet with an APO, with an agency protest official, and say, hey, I know you have in your file the following 3 documents, just redact those 3 documents and give them to me. That's an argument they can have. Whereas if the protester says, hey, give me your entire administrative record redacted, that's unreasonable. But knowing that the file has been constructed and it only wants a few documents out of that file, that's a workable part of the negotiation.
Okay. All right. Any other thoughts on the finally paragraph? Looking, reviewing, seeing nothing. Okay. All right. See, isn't it a lot faster to go through the preamble? This is great. All right. Let's do agency level protest paragraph, and the end is in sight here. Let's go.
Yeah, this whole paragraph turns, sort of does a 180 at the end, which I like for dramatic effect, but it is. A little jarring.
It doesn't faze me, but there's a lot of very good writers on this Zoom. What do folks think? Eloise?
Can I actually go to the opening sentence of the paragraph first, though?
Of course.
I didn't understand the structure of this paragraph, Chris. Is this supposed to be another rationale for why fewer agency level bid protests are brought, because the agencies themselves sort of have constructed all sorts of barriers to dissuade them?
Yeah.
It read, and then coupled with the dramatic turn at the end, as you put it, I got a little bit of whiplash in this paragraph, just like where it was coming from. So if you have 4 reasons, or if we have 4 reasons that we've just been through as to why the kind of lower numbers of agency level bid protests stem from the vendor side, I just thought we could have a sentence that clarifies that another reason why, or agency bid protests are also, it is not just vendor dissatisfaction that results in lower numbers of agencies themselves have reasons to something. I just wasn't sure what you were trying to go for in this paragraph, which is why I was confused. And then I also was confused between this paragraph and the next paragraph, where we claim that agency level bid protests are supposed to be good for everybody, because we just then spent a paragraph talking about why it wasn't so good for agencies. So the combination, I was a little confused by.
Yeah, so I don't want to speak for Mark and the ACUS folks who wrote this, but I think that if we wanted to improve this paragraph, we might just create a topic sentence saying agency level bid protests are ripe for reform, and then talk about the fact that if they are improved, if the processes are improved, then there will be fewer follow-on disruptive protests.
See what that looks like.
Under the current structure, comma, they can be, or under the current system, or I don't know,
Yeah.
Chris, is that
Yeah.
right?
Yeah. I may be trying to do too much with too little here. What we're trying to get at here, Mark, you may just want to just highlight the whole paragraph and say that the goal here is to say that that under the current system, there are too many follow-on protests, and there needn't be. If the agency level protest process itself is transparent and fair.
I can make one wording suggestion for your consideration. Somebody used the phrase alternative dispute resolution earlier, and I thought that would be a useful add-on to the paper somewhere. And maybe this would be the place for it. Something like, if this alternative dispute resolution mechanism worked more effectively, then maybe there'd be fewer, if people were more confident in agency level processes, they might be less inclined to have the follow-ons.
Yeah. And to Judge Braden's point about that, about the agency level, the FAR 33.103 does talk about it. It looks like a classic contract provision where you're structuring an ADR process. It says the contractor and the CO are supposed to try to resolve things before they start things, but really is an ADR process. You're right.
So in the interest of everybody's best use of time, between now and when we circulate, we will see what we can to fix this up. I think this is helpful. Conceptually, let's not talk about words. Let's talk about concepts. Is there any concepts that we want to put in this paragraph that you'll see by next time that we don't already have? Look, yes, Anne?
I was the one who had raised the ADR point in the context of the GAO, because they actually track what actually gets resolved through ADR. So I would like some mention of it here. I mean, the idea, right, to make these more attractive is the sense that they're more informal, and they're going to be, hopefully, with these recommendations, quicker and more attractive both for the agencies and for disappointed bidders.
Okay, I'm looking, seeing nothing. So we'll fix this by next time. We'll send around a red line so you can see where we ended up on this one. Let's look at the protesters and agencies paragraph. Eloise.
Okay, Aaron, so you've called me out. So I'm now feeling really kind of guilty for having marked it up so much. But anyway, you and I could talk about that offline. I'm going to reiterate my hope that we can include the public as a valued entity in this paragraph. So if we could just add a sentence about why an improved process would be better for the public, I think that would be great. Parallel to the two other times where I think we should have something about the public.
Yeah.
I have a couple of other thoughts. Aaron, should I keep going? Or you want me to?
Where would you put that sentence? We don't need to draft the sentence now, but where would you put it? You want to put it, the public, protesters and agencies all benefit, and then we say the public because then protesters benefit, then agencies benefit. So the sentence would be the second sentence in the paragraph, or what's your structure?
I haven't given it too much thought. I a little bit feel like public might come at the end as the dramatic aha, and also look, we're a government for the people. But that is, so then we go from the micro to the macro.
Let's do it.
But I don't really feel strongly.
Nope, sounds good.
That.
We'll come back with language on that for next time.
Okay.
We'll let Mark finish writing, and then you can pick it up. You ready to roll, Mark? Thumbs up? Okay, take it, Eloise.
So then just a couple of thoughts about tense and parallel construction. So don't we mean that all these people would benefit? It's not that they do benefit, it's that they would benefit. So I would insert a would in front of every sentence. So protesters, agencies, and the public would all benefit. And then protesters would benefit because agencies would benefit because the public would benefit, because I think that's more consistent with the hopeful tenor of our recommendations.
No, any objection to that? No objection. I think that's very helpful. Let's use woulds.
So, okay, continuing. I don't actually think robust, which is the word that we keep using, is what we mean. I think we just mean improved, right? I mean, there is kind of a robust system. It's just that people aren't using it well or aren't using it right, and we're just proposing improvements to it. Or maybe we're making it more robust, but I think improved is the word we actually mean. And so I would prefer that to robust, or if people feel strongly about robust, I would suggest that we do and improved. And then I had one final thought on this paragraph.
Let's make sure everyone's okay with, I confess, I have no strong feelings between robust and improved, so I'm happy to defer to you, but I want to make sure that that is consistent with the room. Looking, I'm getting thumbs up. All right, it is improved, not robust. And
who says one person can't make a difference?
Do a comment bubble. We're going to do consistent throughout. Make sure we haven't missed any. Okay, and one more.
I'm so sorry.
No.
In what I guess is now at lines 67 to 68, we're squishing in two different ideas about why protesters would benefit. I found the second one to be slightly confusing, but also it's just a second idea. And so I was hoping that we could do period, and then protesters would also benefit, and then explain it with a little more clarity. I got a little bit lost about this, especially because we don't really return to it in any, or is there something in the report? I just didn't really remember this. I was a little bit confused about the reputational point and wondered whether it could be clarified in some way.
Chris, do we have something like that in the report?
Where is it? I'm sorry, I didn't see the reputational reference.
Well, maybe again, I'm just not understanding it properly. But in that set, yeah, the one that he's just highlighted, the low, yeah. I just didn't understand the logic of that sentence. Why would an agency have less bad feelings about a protester who did it in the agency?
Because you haven't publicly humiliated them. The reputational capital that the agency official loses is probably the most acute sanction in the whole bid protest process.
So the reputation we're concerned about is of the agency, even though line 69 says adverse view of the protester. So do you see what I'm talking about? It's like the reputational, the emphasis, whose reputation is at stake, is flipped from what we actually mean then. That's why I think I was getting confused.
Okay, so what we mean is the embarrassment to the agency official. And as a result, the agency official will typically be very angry with the protester.
But then why is that a benefit to the protester and not the agency?
Because the protester, if the protester can go through a process that reduces reputational risk to the agency customer is more likely to take corrective action.
But like in a repeat player game, like will the protester wants a second contract down the line, and so that's the concern?
Yes.
Or,
Okay.
or Eloise, as I understand it, they already have contracts, and so like any modifications that they're looking for on those contracts, like there are a lot of big players and they're juggling many contracts, especially at the big agencies.
Yeah.
So then if we can, maybe it's just a because clause with an adverse view of the protester because of the public, I don't know that we want to say embarrassment, but the publicity brought.
So here's my reaction to this, and those who've been in enough meetings with me know that I always like to go less than more. I'm inclined to say protesters, for instance, benefit from, and just end at that first clause and not get into this, which is kind of confusing, and it's going to be a mess, and it's in a preamble anyway, and it's not necessary for the argument to hold. So that would be my instinct, would be just to take out that entire clause and just leave it as it is, that they benefit from a lower cost, easier system.
Okay. Just
I could be wrong, like just because that's what I do doesn't mean it's the right thing to do. But that's my instinct on this, is if there's confusion in a preamble for a point that's not necessary for the argument to hold, just drop it. I'm looking around the room. Nobody disagrees. All right, we're dropping it.
So for Aaron, for you, and for the ACUS folks that might be involved in the Hill, just to put a bit of background of this, the Germans estimate that 5% of their procurements are protested. The RAND study that we've been talking about estimated that I think it was around 0.3% of federal procurements are protested. There's a huge number of errors that are not that are not being protested. The idea is to make the agency level protest system work better, cheaper, faster, in order to allow more of those errors to be addressed.
Okay. All right. Let's do the last paragraph here. This is when we have a comment bubble. So I want to leave us a little bit of time to do that, and then we will spend the last 10 minutes on the recommendations again. So let's go through this last one, and with thoughts on the comment bubble in particular.
Do you have to say this, Aaron?
Who is that?
This is Chris. Do you have to say any of this?
No.
Sort of on the modality?
I don't think we have to. But all right. So, I mean, as we've structured it, we've told Congress where Congress has to do it. We've said when the FAR has to be changed, the FAR has to be changed. When agencies have to do it, agencies have to do it. Is this an artifact of an earlier version of the recommendation that no longer is necessary? Well, this might be a question for Mark. Mark, can you put you on the spot here, can you think of recommendations where we need to have this language for it to make sense?
No, I think to the extent it was helpful, the changes we've made have largely rendered it kind of superfluous.
Chris, do you agree with that?
Yeah, my report, I was very reluctant to be this prescriptive because things happen suddenly in the reform process.
Well, again, my theory is always less is more. One day we'll have recommendations, just a blank page. So I'm inclined to say let's drop that, unless anybody has a strong reason not to. And then the whole world is just cleaner if we do that. I'm looking, let's cut it out. Great. So doesn't that feel like refreshing? The world just is a better place without a clause with like 3 subparts and whatnot in it. Now, I know what Eloise is going to say here about the start of this paragraph. which is we have contractors and agencies, but we say nothing about the public. So I think we need to start this because a robust agency level process is of value to the public, contractors, and agencies, and drop alike. Is that what you're going to say, Eloise?
I was going to save myself for the last paragraph, having commented too much on this. but Aaron, your thumbs up to you.
I think we should add the public in that paragraph, and we should put public in front of contractors and agencies. And drop alike, because alike doesn't work as well with 3.
Aaron, really quickly, just for parallelism, do we want to have public at the end? Because I believe we had public at the end the last time we did this trio of, protesters, agencies, and the public.
Then yes, let's go with parallelism. All right. Other than that, are there any concerns with this paragraph? I'm looking. I'm not seeing any. Okay, well, this is what we're gonna do. Well, I'll ask the crowd what we want to do. This is the unusual situation where we're going to look at this again because we're not voting for a week. Would it be better to go through and ask if anybody has any thoughts on the recommendations, or are we all done and we're going to have a chance of this via email? So let's just be okay for now and go back and forth for email on the recommendations.
Well, no, I'm sorry, Aaron, what about this? What about the paragraph that Eloise wanted to talk about while each recommendation has been crafted?
Oh, I'm sorry. Eloise.
Thank you, Chris. But Aaron, you'll like where my direction is going, which is, do we need that paragraph? Isn't that just like implicit in everything that ACUS does? Oh no, Chris says it is important.
No, you're exactly right. You are exactly right, Eloise. And
okay.
worse yet, the agencies will point to this paragraph as they deviate perversely from our recommendations in their supplements to the FAR.
I'm fine cutting. We already put some feasibles in where appropriate in the recommendations themselves. So I don't think we need a meta feasibility here. So unless anyone objects, I say let's cut that paragraph. Seeing no objection, that paragraph is cut. And what I'm inclined to do, and I saw Jennifer nodding her head yes, is we're going to send this around to everybody. Before we vote, look at the recommendations again. Let's not do it again now. We'll have our own time. Take it while you're walking your dog or whatever. Just take some time and give it a read, and we'll have a chance to vote again. So unless anyone has anything that they want to add, I'm inclined to call the meeting to a close. And going, gone. There we are. Thank you, everybody. We will send this around after, or whether we hear from DOD. If not, hopefully we can have just a vote by email. If we get substantial response, we'll have another meeting. It's not going to be 3 hours. I will not allow another 3-hour meeting on this, but we'll see. It might be an hour, but hopefully we can do this just via email. Thanks, everybody.
Take care. Bye-bye.